Hey everyone, so Anik is out. She is actually on her way out to New York right now as we speak. Today is Friday, May 30th. Yeah, May 30th. And so just for the purpose of time stamping this show, we are airing this on June the 2nd. But what a week for trade this week. We finally heard some rulings, and Anik is going to be kicking herself in the butt for not being here this week because it was a very big week, and in the sense of just decisions on tariffs. I mean, again, of course, that's all we've been normally talking about lately, but this week was a big week. Let's start. I wanted to start from kind of not the very beginning, but more or less just put a little bit of a timeline here and talk about how we got to where we are now. And my guest is going to be amazing. He's a litigator with Sandler, Travis, and Rosenberg, but he's going to be amazing at breaking this down and the law and everything. I've been wanting to do this show actually for a very long time. And coincidentally enough, on the day that I reached out, that same day, the first ruling came out on the I'm not going to call it repeal of tariffs, but just the decision on some of the lawsuits that were going on and arguments as to why the Trump why the president doesn't really have a tariff powers and stuff. So, but anyway, let's go ahead and start with April 2nd was Liberation Day. Of course, that's when everything was announced, and there was a 10% universal tariffs or on everything, 30% on Chinese and 25% on some stuff that came in from Mexico and Canada. So that kind of started everything. Soon after that, on April 9th, they didn't repeal it, but they kind of gave Mexico and Canada a sort of a stay in the sense that if you were USMCA and you can declare USMCA, then you were able to declare or go back to or get rid of those 25% additional duties. And I say that only because people think, it's 25% on stuff that came into the U.S., let's say from Mexico and Canada, but that's not true. It's 25% above and beyond whatever your normal duty rate is. So if your tariff said it was 5%, then it was 5% plus 25. They got rid of the 25, not the 5%. So, again, clarification, we talked a lot about that, and we wanted to make sure, that was still understood. And thus, the big need for USMCA started at that point. A lot of people were not doing USMCA because their duties or their duty rate on their tariff was 0% anyway coming into the U.S. That suddenly changed because if you were not doing USMCA or declaring USMCA, then that was suddenly the additional 25%. On April 23rd, that was a big day. So on April 23rd is when we heard several states filing lawsuits with the against the Trump administration, challenging the legality of the new tariff policies. Then we move on to May 12th. That's when U.S. and China agreed to a 90-day suspension of the tariffs, going down from in China, us assessing up to 145 down to 30%, and then China lowers ours from 125 down to 10%. But they both still kept that 10% duty baseline tariff. So that's still there. On May 23rd, Trump threatened again tariff on all imports from the EU. So that came about just recently. We heard a lot about that, and that was supposed to kick off on June 1, which is on Sunday, yesterday, as of the day of this airing of the show. So anyway, we'll see. And it says that on Apple, the administration warns Apple of a 25% tariff unless it ships its iPhone manufacturing to the U.S. Wow. Okay, so that's not going to happen. So then the big day, May 28th. That was when, and I'm going to read this because I don't want to get this wrong. A 3-judge panel blocks most of Trump's tariffs, ruling that they are unconstitutional. And so that put a pretty much a halt on all the tariffs that were happening just yesterday. So today is Friday again, but yesterday, Thursday, on the 29th, district court on appeal said, well, no, you can still do tariffs, so they went ahead and continued the tariffs until they hear the final. I guess we'll find out from Jason. So sorry about that. But anyway, so let's bring in now Jason. So Jason, Jason Kenner is from Santa Travis and Rosenberg. As I said, he is practicing a litigator at STNR. And I think you said you were based out of New York, if I'm not mistaken.
Yes, I'm based out of the New York office. And I've been with Sandler Travis for about 3.5 years, and for about 14 years prior to that, I was actually with the Department of Justice, the International Trade Field Office, which is the one of the DOJ offices litigating these IEEPA cases. And I just want to take a step back because the lawsuits kind of got kicked off on April 3rd, the day after Liberation Day. The first lawsuit was filed in the Northern District of Florida, and that was the Emily Lay Paper case. And just I'll give a quick update on where all the other cases are before we get to the merits decision. So that case was just transferred to the CIT. The government's motion to transfer was granted, and that case is now before the CIT. The next case to be filed was filed on April 4th, 2025, and that was the case filed in the District of Montana. That case also had a motion to transfer filed by the government, transferring it to the CIT. That motion was also granted. However, right now, pending before the District of Montana is a motion for re-argument on that motion to transfer. So that case is still technically in front of Montana, and we're waiting to see how that motion plays out. The third case to be filed outside the CIT was filed on April 16th, 2025, and that was filed by the state of California in the Northern District of California. Currently pending before that court is, again, a motion to transfer filed by the government. That motion was argued on I think last week, May 27th, and decision on that motion to transfer is still pending. Then you had on April 22nd, you had the case filed in the District Court for District of Columbia, and we'll kind of get to that case. That one had an opinion on a preliminary injunction motion filed or was issued yesterday. And then you have several cases actually filed in the CIT. The first one filed in the CIT was actually filed way back, actually before anyone else, and it was Barnes v. President Trump, but it was a pro se case, and that case was recently dismissed for lack of standing. Then you had VOS selections. Then you had the state of Oregon, and then there's a third case still pending, and that's Princess Awesome versus the United States. That one is set on a briefing schedule. In fact, it's supposed to be fully briefed by the end of today, so we'll expect a decision out of that case probably relatively soon. So, yes, on recently we had the merits decision that came out on the VOS and the Oregon case. The court issued a single opinion on both cases. What the court determined was that neither the reciprocal tariffs, we'll call them, or the fentanyl tariffs were authorized under IEEPA. There was a lot of constitutional arguments in a lot of heavy doctrine, political question doctrine, major questions doctrine, non-delegation doctrines being argued back and forth between the government and between the plaintiffs. But what the CIT ultimately ruled upon is strictly the four corners of the IEEPA statute. What they first had to determine is, what does IEEPA allow the president to do? Does it allow him to issue tariffs? And what the court determined was, well, first, we look at IEEPA, and it does have that broad language, regulate importations, but does it allow the broad, unprecedented tariffs that were ultimately initiated for the reciprocal tariffs? And what the court said was no, because if we were to interpret IEEPA to allow such broad tariff authority, then we would be rendering this, an unconstitutional statute. And what the court said was, listen, you have to look at, the predecessor statutes, Trading with the Enemy Act, and then you have to look at what happened in IEEPA. IEEPA took that emergency powers out of the Trading with the Enemy Act, put it into IEEPA. and at the same time created Section 122 of the Tariff Act, which also created a power to levy tariffs in situations of deficit, payment deficit issues. And basically what the court is saying is saying, listen, the power to remedy trading deficits, things of that nature, that was encompassed by Section 122, and 122 is not part of IEEPA. Ergo, what you've done here is not within IEEPA, but you could do it under Section 122. And then they turn to the fentanyl tariffs. And the court was very careful to say, listen, we're not going to second guess the president of whether fentanyl is an emergency, whether it's unusual or extraordinary. What we're looking at is what are the requirements of IEEPA. And one of the requirements is the action taken has to, quote, deal with the perceived emergency, which is unusual and extraordinary. And if you had listened to the oral argument of the government on those cases, what the government essentially argued was, well, the fentanyl tariffs don't directly deal with the fentanyl issues. What it does is it creates a situation, it creates pressure which the president can use, leverage it can use to change behavior of China, Canada, and Mexico to deal with those issues. And what the court said was, no, deal with has to be more of a direct link. And they kind of gave the example of how a dam deals with flooding. It directly holds back the water. And what they're saying here was these tariffs, while they may create a situation or leverage that the president can use to deal with the problem, it is not itself dealing with the fentanyl crisis. So it says those are also not authorized under IEEPA. The government immediately that evening filed its notice of appeal. It has also filed a motion to stay the enforcement of that order. It first filed a motion to stay in the CIT. That motion is pending. It also filed a motion in the CAFC and has indicated it may also file a motion for emergency stay in front of the Supreme Court. And what the CAFC has granted to the government right now is a temporary stay. It's a temporary stay that will remain in place up and until the time the court has an opportunity to rule on whether a motion to stay pending the outcome of the appeal is appropriate. So it's temporary stay. It may turn into a permanent stay pending the outcome, or it may not. They have issued a relatively aggressive briefing schedule on that permanent motion to stay with the government or the plaintiff's brief. The plaintiff's brief due on June 5th, and I believe the government's reply is June 9th. So that motion to stay, whether it's going to remain through the pendency of the appeal, that is up in the air, and we'll know that sometime after June 9th.
You mentioned, and I guess just for the sake of anybody who's listening and is not much into trade, CIT is the Court of International Trade, and then there's also you said CAFC. That's the Court of Appeals, right?
Yeah, that's the Court of Appeals for the Federal Circuit. That is the appellate court that sits above the Court of International Trade. And, just a little background of I call it the CIT. Something I find kind of humorous is all the articles that have been written about the CIT all start with the same thing: low profile, relatively unknown. A lot of adjectives to describe the CIT, but I find that rather amazing because the CIT it's a district level court. It has all the same powers as a district court, but it has a more narrow jurisdiction, and that jurisdiction is tariffs and trades. But unlike a district court, the CIT has nationwide jurisdiction. While a district court is geographically located and that's where their jurisdiction lies, the CIT has nationwide jurisdiction. And on top of that, another interesting thing is if a matter falls within the jurisdiction of the CIT, it cannot fall within the jurisdiction of a district court. It's one or the other. Either the CIT has it or a district court has it. It can't be both.
And why would the U.S. government want to move it to CIT versus district court and or vice versa? I mean, I think you said most of it were motions by the U.S. government to move it to the CIT, correct?
Yes, the government uniformly moved to transfer any case challenging the IEEPA that were filed in a district court. They uniformly try to move all of them to the CIT under the court's exclusive jurisdiction. And I think there's a couple of reasons for that. First, I think because it is the CIT that is the appropriate court of jurisdiction for this matter, but also the CIT has some special processes and procedures, one of which is called test motion and suspension. So you're not litigating many cases at once. If it were the district courts that had jurisdiction over this, the federal government could face hundreds and hundreds of motions filed all around the country, versus centralizing it in the CIT, where they can litigate one case and at a time, essentially. So I think it's because the government believes that that's a proper court, and also because it is probably a more convenient forum to litigate in such a large mass of cases.
Right. Okay. So you were. This is pretty cool that we have you on the show, because right now we have you on, let's say, defending or could defend or litigate for the public or the states and stuff, where before you were defending, right? So we see both sides, and which is kind of what we're seeing right now is that we're seeing like almost a tennis match, right? Like one hits, they're volleying the ball back and forth to each other, and the court says yes, and then the court says no, and then let's put a stay on that. So let's try to benchmark a little bit as of today. Where are we at? We still need to pay tariffs, and based on everything that Trump has had, right?
Yes. Again, there is a temporary stay. At a minimum, a temporary stay that has been issued by the Court of Appeals for the Federal Circuit. That's going to remain in place up until the time the CAFC decides on whether or not a stay for the pendency of the appeal is appropriate or not. The CAFC could, again, stay this for the entire until the appeal is heard. If the government doesn't get the stay from the CAFC, chances are great that they'll go to the Supreme Court to try to get an emergency stay at the Supreme Court. So I think there's better than reasonable chance that the order would likely be stayed pending the outcome of the appeal. But the appeal just kind of became a little bit more complicated because, as I said, it's either the CIT that has jurisdiction or a district court that has jurisdiction. And the day after the CIT renders its opinion saying it has jurisdiction, you get the DC District Court rendering an opinion on a preliminary injunction saying, no, it's not you, CIT, that has jurisdiction. It's me, the district court, that does. So you in addition to the merits of the ultimate challenge of IEEPA, now there's an issue of which court truly has the authority to hear this challenge. And what the DC District Court said, a little different than what the CIT said, which the CIT essentially says that tariffs could be appropriate, but essentially not under these circumstances that we're facing here. What the DC District Court said was that IEEPA is not a tariff statute. Essentially, IEEPA would never authorize tariffs under any circumstance. And because IEEPA could never authorize tariffs, that it is not a tariff statute and doesn't belong in the CIT. So you have these two diametrically opposed views of IEEPA and jurisdiction that also will have to be vetted. And I note that the government filed its appeal of the preliminary injunction opinion from the DC court yesterday as well. So while the VOS Oregon case is in front of the CAFC, you have the learning resources case in front of the circuit court for DC. And again, now we have dueling jurisdictional fights.
I did have a question regarding a little bit of kind of like just why the states are even saying this, and why even Congress, folks in Congress on both sides of the aisle, believe it or not, have been saying this. The way the Constitution is written and the way it's like in black and white, I guess, right now, if you want to read it like verbatim, I guess, or not verbatim, but as it's written, it says that Congress is who is responsible for setting tariff policy, correct?
Absolutely. Article 1, Clause 1 gives Congress the power to levy tariffs. But that doesn't necessarily mean that Congress cannot give to the president certain authority, and we know that they have. We know that the Congress has delegated certain tariff authority under Section 122, under everyone's favorite Section 301, 232. So we know that Congress can delegate such authority to the president, but it has to be within certain bounds. It has to be, we have limits and guidelines and guardrails and a whole host of other things. It has to be clear. And the fight here is IEEPA is not clear. If Congress wants to delegate such a huge amount of authority over something that Congress has sole exclusive authority over, it should be clear. And according to the states and according to the plaintiffs, IEEPA is less than clear. It says regulate importations, and they contrast that with 301 and 122 and 338. They contrast the language where in those statutes it's very clear. They use the word duties, tariffs, things like that, but IEEPA doesn't use that type of language. So that's where the crux of the fight started over what does that term regulate mean. If it does mean tariffs, does that pass muster under the major questions doctrine? Does it pass muster under the non-delegation doctrines and things of that nature? And again, while neither the CIT or the DC Circuit actually ruled on those grounds, that's kind of where the crux of the fight started. If IEEPA does allow tariffs, it violates all these constitutional canons of construction. And again, both courts have been careful to kind of sidestep those issues and look solely at the plain language of the statute, both coming out the same way, but for different reasons.
So I'm now that you say that, now that's triggering something in my head, and I'm thinking, okay, at one point or another, this is going to end up at SCOTUS or the Supreme Court. And, whether the administration wins, so the other side is going to push it all the way up to the Supreme Court, in my opinion, or the other way, right? Of course, if Trump doesn't win, then he'll push it up there. So this kind of brings up something. Let's say, from what you just said, I don't know why I'm interpreting in my head. I may be completely wrong, but I'm interpreting in my head that because it's not very clear, the administration may end up on top of this, and win at the end of the day.
I think the lack of clarity plays against the government because, again, delegations of congressional authority to another branch has to be clear. Well, the government argues that it is clear. It's clear because Yoshida says that that similar language that was interpreted under the Trading with the Enemy Act, regulate importations, has already been interpreted by the court to include the power to levy duties. And Congress knew of the Yoshida opinion when it drafted IEEPA, so it's very clear that they also meant regulate to include tariffs. That's the government's position. Clarity benefits the government. The murkiness benefits the plaintiffs because, again, you can't delegate such a broad, huge, giant power that impacts the entire economy with less than clear language. And again, neither court ruled on that ground. The D.C. District Court says it's clear that regulate doesn't include tariffs, and therefore you could never do what you've done here. The CIT said the language is clear that that IEEPA doesn't allow the reciprocal tariffs because that's for Section 122, and it's clear that IEEPA does not allow for the fentanyl tariffs because you have to issue your action has to, quote, deal with. Because that's the plain language of the statute, deal with the emergency. And by the government's own concession, all that the fentanyl tariffs are doing are creating leverage that can be used to deal with the emergency. Again, one step removed. And according to the CIT, that's not what the statute requires. It has to be direct, like a dam holding back a river. So it has to be something more direct to stopping the flow of fentanyl, not creating leverage that you can use to do something to require the foreign governments to stop the flow of fentanyl. So
okay. So what I was thinking is the other way around, that because it's not as clear that he will eventually prevail, and the courts would send it back down to Congress and say, make it clear, so that and which I guess would be a congressional act at that point, I guess, just to make it. Well, I'm sure at the end of the day, it's still going to go there, right? I mean, let's make it super clear whether they win or lose, and it's may end up back in Congress so that it can be. I don't know. I mean, I don't know. I mean, history says that in the midterms, the Republicans may lose their power in the House, maybe even in the Senate. I mean, that's just the way it is. I mean, Biden started with a majority on both houses. And so did Trump, and it tends to be that way. And at the midterms, they lose it. So I wonder how much that's going to affect any policy making. I always think to myself, that's why Trump is pushing everything really hard in this first 100 days, because he's fearing that maybe in the midterms he may lose that majority, and he won't have as much policy making power at that point.
Yeah, I agree with you. But even if the plaintiffs prevail all the way to the Supreme Court and Congress doesn't do anything, it doesn't stop the president from impacting tariffs. Again, he has other tools available to him, and in fact, the CIT sets forth 122 as the proper tool to deal with this trade imbalance. So it's not that a loss on IEEPA means that it's going to be hands-off tariffs. It means that it's hands-off tariff using IEEPA, which can be can be boundless, limitless, and done very, very quickly. 122 again, it has a maximum of 15% and 150 days that the duties can be in place unless Congress acts otherwise. So there's just much more constraints on the other tools. And if you agree with the government's argument, IEEPA is unfettered, unreviewable by courts, and boundless and limitless. So even if he loses all the way up, it simply means you can't do it this way. And maybe there are some sort of guardrails and bounds, but it doesn't mean again that he can't come back and try to to increase tariffs through other means.
Okay, so let's talk also now. Let's switch a little bit more into what our listeners are probably sitting here is like thinking, okay, good. So now we know all the history, background, and everything. Now, what about us? I guess let's talk about like real world impacts. Let's see. As of today, Friday, it's pretty much status quo, right? As if nobody had ruled anything, right? I still need to pay my duties, taxes, etc., right?
I would agree that it's status quo, but I think people have to start thinking about monitoring their liquidations and things of that nature. To the extent that this is affirmed, or to the extent that it's not stayed, start thinking about potential methods for protesting or getting that money back and certain matters. So again, while it's status quo in paying, I think people have to have in the back of their mind to start watching their liquidations, protect those liquidations, so they have the opportunity to potentially seek refunds at the end of the day if the plaintiffs are ultimately prevail. But again, that temporary stay that's in place today, it may go away. We'll know more about that after June 9th when the motion to stay is fully briefed.
So as of June 9th, I guess that's where we're waiting on now. So yeah,
June 9th is the day that motion will be fully briefed. I don't anticipate the Court of Appeals taking long to decide it. After June 9th, I think the thing is the government has for the stay, the government has an argument that looks it's good on its face. They're saying listen court, there's no harm to plaintiffs if you stay the action because there is this method for getting their refunds with interest. But look at the flip side. If you don't stay this opinion and we're not able to collect these tariffs that the White House has imposed, and this litigation, the appeal takes 8 months, 12 months or longer, and it's reversed, we may never be able to recoup that money that we should have collected. So that's the kind of the facially valid argument that they are presenting to the Court of Appeals. But that argument is kind of superficial because it doesn't take into account all the folks who can't afford to pay the tariffs and are going to go out of business, and it doesn't take into account all the lost business, lost customers, all those things that are going along with having to pay such exorbitant tariffs. So we shall see what happens, but I suspect if the Court of Appeals doesn't give it to them, they're going to go to the Supreme Court.
Yeah, that's where I think it's ultimately going to end up anyway.
When I say go to the Supreme Court, and I'm talking about just to get that emergency stay.
Oh, I see.
Yeah, and then because I was actually looking at the Supreme Court's what they call the shadow docket, and that's one of these emergency. And the Supreme Court, I think, has given 9 emergency stays to the current administration. So they've been relatively generous with emergency stays. So what they would do is go seek a stay of the CIT's opinion while that matter is heard by the Court of Appeals. So it still would have to go through the Court of Appeals and then a decision rendered and then seeking cert.
How do you think, I guess either side is feeling about this? Do you feel like the administration is a little panicked about this, or do I mean, I know the way Trump comes about, and he's very, very confident about everything he's doing, but like, what do you feel like his staff might, not his staff, but his folks that are fighting this for him, or on the other side, like how do the states and
I think the plaintiffs have to feel pretty good. I mean, they're coming off essentially 2 wins now. While there's dueling jurisdiction, but two courts have now said that these are invalid duties. I think both opinions are pretty well reasoned. I think the plaintiffs' arguments are the stronger of the two, and I do think that the government has a pretty steep uphill climb to get this reversed. But I note that in press conferences just yesterday from folks from the White House, they're saying, listen, if we don't do it this way, the CIT has already given us a roadmap for 122 and the other provisions. So how they feel about this, if they don't feel so great about this, I think they're going to be belt and suspendering themselves and start moving forward on those other alternative methods and tools that they have to impose duties.
I mean, and I guess obviously consumers and importers are elated at the possibility of this, going away.
I think folks are elated at the possibility, of these going away. But again, now it's even more chaos. Speaking to many clients, I've been given the same message. Jason, we can deal with tariffs. What we can't deal with is uncertainty. And if anything, these orders and in the stays and the appeals are just throwing more uncertainty into the system.
Right. Imagine being an entry writer right now too. So. Well, anyway, so there was also, I guess, another thought or an idea of, to me, although obviously this has a lot of negative impact, or not impact. I'm sorry. Let me restate that. It has a lot of negativity coming out in the media because, of course, there's a lot of impact on businesses and consumers. But how do you feel about? I mean, and I guess this would be just a Jason opinion more than anything. But like, I feel sometimes that at the very least, it's like gotten everybody to open up their eyes and realize, that what and how American products, are consumed or even treated across the world, and just kind of like, just tough love, let's call it. Sometimes when you just have to tell someone, hey, you just got to buckle down and do that. I mean, this is kind of like, pulling off the Band-Aid almost, what I mean? Just yanking it off, and instead of kind of doing it slowly or diplomatically like the way normally is done. So
I'll take that in two pieces. First, I do think that this has opened folks' eyes to supply chain. It's opened folks' eyes to duties, tariffs, how they work, how they impact prices, things like that. Certainly opened the eyes of everybody that there is a court of national trade, which nobody apparently knew before, other than trade folks and trade attorneys. But I have heard a lot of the sentiment about pulling the Band-Aid off, bringing production back to the United States, and things of that nature. But in talking with folks and in business folks, what you're looking at is an extreme long-term investment into factories and in plants and things of that nature. But tariffs and duties, especially these ones, by their very nature, are transitory. Even if these stayed in place, through the current administration, chances are the next administration is going to undo them. So, I think there is a certain sentiment to bringing things back home and jobs and things of that nature. But I think the reality of it is this is costing American taxpayers and American businesses a lot of money, and at the end of the day, it is somewhat transitory, 3-4 years, maybe most. And is that really long enough time for people to invest in plants and things of that nature? And I don't think so. So I think this is causing a lot of chaos, costing a lot of money. But at the end of the day, I'm not optimistic that it would achieve the desired result.
I agree. So I know we're running out of time here. We're not running out of time, but we're coming here towards the end. And I wanted to make a few more comments, but we'll hold it off for another time in another episode. But any closing arguments?
No, I just think people, really need to stay tuned to all the changes that are coming. I mean, we still have the California court still, waiting to decide whether they're going to transfer the case or keep the case themselves. We still need to see whether or not the CIT order is going to be stayed, and we need to see whether the district court opinion is going to be vacated for jurisdiction, or if that's going to have to be decided by the Supreme Court, who has jurisdiction. So, this was a major milestone, these decisions, but I think it's a first step in a very, very long journey.
Needless to say, I guess importers may and will or should, I guess, in many cases, consult with folks like yourself just to make sure that they're following the current laws and regulations. So, but thank you, Jason. This was awesome. The first time I've met you, and I don't know. I know I was at a event for Sandler, Travis, and Rosenberg in November, more or less. And were you there?
Yes, amazing event. Yes,
Yeah,
I was
fun.
definitely there.
Yeah. Okay. So I obviously there were so many people there. I met a bunch of people. I may have said hi to you or not. I don't know. But anyway. Nice to meet you or talk to you here in the podcast. I'm glad we had a chance to talk, and for sure I want to have you back. We have this segment called Simply Trade. That's the name of our show, obviously, Simply Trade. But we have this segment called Crimes, Simply Trade Crimes, and I am willing to bet you can break down a case really well. I mean, the way you speak and everything. So it'll be fun to do we call it what were they thinking? Kind of like.
Well, that would be, you're definitely right in my wheelhouse. The last several years of my time at the Department of Justice, my main responsibility was investigating and prosecuting 1592 cases. So that was my bread and butter for many years, and those issues they're still very close to my heart.
Yeah, I like that. I have a friend who used to work for. She was an attorney with a district attorney here, with a DA here in our city, and now she's practicing private. I like to talk to her about well, how do you feel about how you used to do this? Now you're defending and everything. So it's kind of fun to talk.
I'll tell you this: I find a lot more conduct to be reasonable now than I ever did before.
Yeah, that tends to be fun conversations. Well, thank you, Jason, again and again. You can find Jason's information on the show notes, again, from Sandler, Travis, and Rosenberg. Thank you, guys. Mark Seacrest from the STNR who helped me connect with Jason and our friends over at STNR. And for now, thank you very much, and y'all have a good one, and keep alert on those tariffs.
Thank you for having me.
Thank you very much for joining us. Simply Trade is brought to you by the generous contributions of Global Training Center. You can follow the show and GTC on LinkedIn or Twitter and other social networks. Make sure you check out the show notes in the description for a full rundown of today's show with all the important links. Also, make sure that you share this with a friend and subscribe on your favorite streaming platform. We really like hearing from you. If you enjoyed the show, make sure to rate and review wherever you listen to this podcast. If you or someone you know would like to be a guest in the show or would like to sponsor Simply Trade or suggest any topic you would like for us to discuss, please contact us via email at simplytrade@globaltrainingcenter.com, or you can DM us on Twitter at simplytradepod. Thank you again for the privilege of your time. Happy trading. Simply Trade is not a law firm or an advisor. The topics and discussions conducted by Simply Trade hosts and guests should not be considered and is not intended to substitute legal advice. You should seek appropriate counsel for your own situations. These conversations and information are directed towards listeners in the United States for informational, educational, and entertainment purposes only and should not be substituted for legal advice. No listener or viewer of this podcast should act or refrain from acting on the basis of information on this podcast without first seeking legal advice from counsel. Information on this podcast may not be up to date depending on the time of publishing and the time of viewership. The content of this posting is provided as is. No representations are made that the content is error-free. The views expressed in or through this podcast are those of the individual speakers, not those of their respective employers or Global Training Center as a whole. All liability with respect to actions taken or not taken based on the contents of this podcast are hereby expressly disclaimed.